This is Lee from the Law School Toolbox. Welcome back. Today, we're going to talk about the rules surrounding criminal identification procedures. When you think of how the police verify that they have identified the correct suspect in their investigation, you probably think of a scene from your favorite crime drama. A group of similar-looking people lined up in a room with one-way glass, while a witness stands on the opposite side, tries to pick out the person they saw commit the crime. This kind of identification procedure is called a lineup, and it is one of several methods police use to identify suspects. We'll begin today by looking at specific rules you'll want to address when a question involves a criminal identification procedure. After that, we'll apply what we've learned to a couple of hypotheticals. The first step in analyzing whether a criminal identification procedure is suspect is to think about the identification procedure used in the question. In addition to a lineup like the one we described earlier, the police may use identification procedures such as fingerprinting, blood or DNA testing, voice identifications, photo arrays, which are similar to lineups in that a photograph of the suspect is included with photographs of other people, and showups, cold shows, or field identifications, where the witness is only shown one person for identification, which are typically used when the suspect is apprehended quickly after the crime occurred. Witnesses are also often asked to identify the suspect in court. Once you have narrowed down the type or types of identification procedure involved, the next step is to think about at what point in the criminal proceedings the identification procedure occurred. Why is this important? Well, because the timing helps us determine whether or not the defendant was entitled to have counsel present during the identification procedure under the Sixth Amendment. You may recall from some of our prior episodes on criminal procedure, the right to counsel under the Sixth Amendment attaches once formal adversarial judicial proceedings have commenced. Formal adversarial judicial proceedings are things like formal charges for a crime that carries a substantial risk of jail time, a preliminary hearing, an indictment, or an arraignment. This is important to remember as you think about criminal identification procedures. Going back to the timing of the identification procedure, if the defendant has already been charged with a crime before a lineup or show-up occurs, the defendant has a right to counsel under the Sixth Amendment, which includes the attorney's presence at the lineup or show-up. A post-charge witness identification made by lineup or show-up without the presence of the defendant's counsel is inadmissible. On the other hand, if the lineup or show-up occurs before the defendant has been formally charged, the right to counsel under the Sixth Amendment has not yet attached, and the lineup or show-up or other identification procedure can be conducted without the suspect's counsel present, though other constitutional protections that we aren't going to cover today may still be relevant. The issue of timing gets a bit more nuanced when the identification procedure is a photo array, fingerprinting, or blood testing that takes place after the defendant has been charged. In this situation, even though the defendant's right to counsel has attached, the defendant's attorney is not entitled to be present during the identification procedure unless the defendant is present. Keep in mind that when the right to counsel under the Sixth Amendment has attached, the defendant's attorney may be present at the lineup or show-up, but the attorney is not entitled to determine how the police conduct the lineup. However, the attorney's presence may act as a check on how the procedure takes form, and the attorney's observations may form the basis for the defendant to challenge the identification. Now, since we're talking about a right to an attorney, you might also be thinking about the Fifth Amendment protections against self-incrimination and right to counsel. However, there is no Fifth Amendment right to counsel in these scenarios. And courts have held that pre-trial identifications, blood tests, fingerprints, and voice identifications are not testimonial in nature, so the protection against self-incrimination doesn't apply. Once the suspect is in custody, the suspect cannot refuse to participate in a lineup or show up. The second issue that comes up in this context is whether the defendant's due process rights under the 14th Amendment have been violated based on the way the identification procedure was conducted. To analyze whether the identification procedure violated the defendant's 14th Amendment due process rights, you will need to decide based on balancing the totality of the circumstances. 1. Whether the identification was unnecessarily suggestive, and 2. Whether the suggestiveness of the identification procedure created a substantial likelihood of misidentification. Keep in mind that the burden here is on the defendant to show that the identification procedure was a violation of their 14th Amendment due process rights. Also, if there is no improper police conduct involved, an identification that was suggestive or conducive to misidentification may still be admitted. In these cases, the reliability of the identification is left to the jury to decide. If your analysis leads you to conclude that an out-of-court identification should not be admitted, then an in-court identification of the subject is also barred unless the prosecution can establish an independent source for the identification. Under the independent source rule, the prosecution must show that 1. The witness identified the defendant in court based on the witness's previous knowledge. 2. The witness's previous knowledge is trustworthy. And 3. The witness's previous knowledge was obtained by the witness in a previous transaction, usually during the crime. Now that we have an understanding of these rules, let's look at a hypothetical to test some of what we have learned. This example is from the February 2003 bar exam, but it has been modified from the original. After Dawn was arraigned on a charge of first-degree murder for killing Vic, the police learned that Wes had witnessed the killing. Aware that Dawn had been arraigned and was scheduled for a preliminary hearing at the courthouse on that day, a police officer took Wes to the courthouse for the express purpose of having him attempt to identify the killer from the photographs of several suspects. As Wes walked into the courthouse with one of the officers, they encountered Dawn and his lawyer, Lou. Without any request by the officer, Wes told the officer that he recognized Dawn as the killer. Lou was advised that the prosecution intended to introduce Wes's identification into evidence. Lou moved to exclude evidence of the courthouse identification by Wes on grounds that the identification procedure violated Dawn's federal constitutional rights to counsel and due process of law. The court denied the motion. Did the court err in denying Dawn's motion? Discuss. Okay, in this question, we have two identification procedures to think about. First, we have the planned photo array, and second, we have a show-up, because Wes only observed one person, Dawn, at the time of the identification. The facts also tell us that Dawn has been arraigned on the charges against him, and he was attending a preliminary hearing, so we know that formal adversarial proceedings have been commenced against Dawn, and his Sixth Amendment right to counsel has attached. Remember that there is no right to counsel during a photo array identification, even if it takes place after the Sixth Amendment right to counsel attaches. Therefore, had the photo array taken place, Dawn would not have had the right to have counsel present. Now let's look at the courthouse steps show-up. Dawn was talking with Lou when Wes made the identification. But it doesn't seem like Dawn and Lou were aware that the show-up was going on. Lou would argue that the police officer was aware that Don would be at the courthouse at the same time as Wes, and this was an intentional setup to create an encounter and conduct a show-up. There are no facts to suggest that Lou was aware that the photo array procedure or this show-up was going to take place. So Lou might argue that his lack of awareness was akin to not being there at all. The prosecution would counter that since Lou was present when Wes identified Don, there was no violation of Don's Sixth Amendment right to counsel. Also, the prosecution would assert that the encounter was an accident and argue that it is not relevant that Don and Lou weren't aware that the identification procedure was occurring because Lou couldn't dictate how the identification procedure was conducted anyway. The prosecution's argument is the winner here. Since Lou was present at the show-up, there was no violation of Don's Sixth Amendment right to counsel. A defendant's right to counsel at a show-up is in part to ensure that the lawyer can make arguments against the reliability of the identification. And when there is police misconduct, argue that the identification should be suppressed on due process grounds. Lou can do both of those things in Don's case because Lou was present, even if he didn't know what was going on at that time. So this brings us to the second issue. Did this show-up violate Don's due process rights under the 14th Amendment? Well, let's recall our rule. The Due Process Clause of the 14th Amendment is violated when, based on the totality of the circumstances, the identification is so unnecessarily suggestive that it results in a substantial likelihood of irreparable misidentification. Also remember that Lou bears the burden of proof. Lou would argue that this show-up was unnecessarily suggestive because the location and circumstances were designed to induce Wes to identify Don as the killer. Since a photo array generally takes place at a police station, having Wes go to the courthouse was out of the ordinary. Additionally, the police were aware of the pretrial hearing and selected the same date and apparently the same time to have Wes show up too. This suggests that the police intended that Wes see Don with his lawyer at the courthouse so that Wes, who was specifically at the courthouse to try to identify the killer, would associate Don with the criminal proceedings. Lou would assert that these circumstances were suggestive enough that it created a substantial likelihood that Wes would incorrectly identify Don as the killer. On the other hand, the prosecution would argue that Don's presence at the courthouse is not, on its own, suggestive of guilt or involvement in a criminal case. Even if the encounter was intentional, Don was not in custody and was moving about freely, which reduces the chance that Wes would misidentify Don as the person he saw commit the killing based on the location of the identification. Also, the officer did not prompt Wes to identify Don. Wes volunteered his identification spontaneously, which indicates that Wes was confident that he was accurately identifying the person he saw kill Vic. On balance, though this courthouse show-up was definitely suggestive, it wasn't unnecessarily suggestive. Therefore, the court could reasonably find that it was not so suggestive that it resulted in a substantial likelihood of irreparable misidentification. Well, that's all we have for you today in Part 1 of our Criminal Identification Procedures episodes. Join us next time for Part 2, where we'll examine another hypothetical that demonstrates these principles. Our podcast is supported by spacerepetition.com. Study way less, remember way more. Spacerepetition.com uses proven science to help you with law school and bar prep alike. Code TOOLBOX at checkout gets you 15% off any product. Thanks so much for watching. Please tune in for Part 2 of this 2-part series. And give us a subscribe, leave us a like or a comment so you don't miss any future episodes.